Welcome back, everyone, and thank you for your continued attention to this important topic. As I've indicated to our previous panels, each panelist will have 7 minutes to speak. Following the conclusion of the panel presentation, commissioners will have the opportunity to ask questions within the allotted period of time, and I'll recognize commissioners who wish to speak. I will strictly enforce the time allotments given to each panelist to present his or her statement, and unless we did not receive your testimony until today, you may assume that we read it. So please use your time to summarize your testimony in the 7 minutes that you have allotted for you. Panelists, please notice the system of warning lights that have been set up. When the light turns from green to yellow, that means 2 minutes remain. When the light turns red, panelists should conclude your statements so you do not risk me cutting you off mid-sentence. My fellow commissioners and I will do our part and keep our questions and comments concise. And so now we're going to proceed with our third panel, which will address guidance for meaningful federal oversight. In the order in which they will speak, our panelists are Nicole Turner-Lee, PhD, Senior Fellow, Governance Studies, and Director, Center for Technology Innovation at the Brookings Institution. Welcome. Patrick Grother, Scientist, National Institute of Standards and Technology. Laura McCleary, Senior Director of Policy at Unidos US. Deidre Mulligan, Principal Deputy U.S. Chief Technology Officer, White House Office of Science and Technology Policy. Welcome. Thank you for being here. I'm going to ask each of you to raise your right hand to be sworn in. Will you swear and confirm that the information that you are about to provide us is true and accurate to the best of your knowledge and belief? Yes. Affirmative from all of the panelists. We'll go ahead and begin with Dr. Turner-Lee.
Thank you, Chairwoman and distinguished members of the Commission for this invitation to testify on this important issue on the use of federal facial recognition technology, and I'll abbreviate it throughout my testimony as FRT. The Brookings Institution is an evidence-based, nonpartisan research think tank, and my own experience intersects race, technology, and social justice and the policies that support equitable AI. I spent the last few months as a member of the National Academy's appointed research commission on the use of facial recognition, which was sponsored by the Department of Homeland Security and the FBI. The committee's final report was published in January 2024 and offers a series of technical explanations, challenges, and recommendations in response to the increasing use of FRT by law enforcement. Concerns around equity, privacy, and the protection of existing civil rights emerge as critical themes in the report, as well as the need to think about future use cases by federal agencies and other police entities, including Customs and Border Control. In my testimony today, I just want to reinforce the report's recommendations, particularly those that support reasonable and equitable standards when it comes to FRT use, and make specific calls to federal legislators in particular to formalize guardrails for law enforcement and other federal agencies using the technology. In addition, when individuals and their families are harmed, we have an obligation to provide some sort of remuneration or appeal to those affected individuals, especially if the government is at fault. In my written statements, I go into more detail on what those will look like. In my oral statements, I'll be brief. I think that you've already learned from the previous panel about the technical inadequacies as well as opportunities that FRT presents. The key takeaway is that if particular features are not commonly training these models, such as darker skin hues, they do not optimize for performance with regards to those characteristics. Indeed, my friend here, NIST's facial recognition vendor test has found that algorithms used by law enforcement perform worse on faces of women and people of color, and there's no mere abstract technical concern here. To date, 6 people are known to have been falsely arrested due to an incorrect FRT match, all of whom are Black, which is continuing a history of discrimination and over-surveillance of people of color. I want to walk you through the case of Portia Woodruff from Detroit, the woman wrongfully arrested due to FRT. One morning earlier this year, she was getting her 2 children ready for school when suddenly 6 police officers were on her doorstep with an arrest warrant for carjacking and robbery. Being 8 months pregnant, she was arrested and taken to a detention center where she remained there for hours. Exhausted upon release, she was taken to the ER, where she was found to have low blood pressure due to dehydration and contractions due to stress. Her arrest was based on an outdated photo processed by Detroit police, which identified her as a match, despite the suspect in the grainy photo clearly not being pregnant. She's now suing the city of Detroit after spending time at the station and money to prove her innocence. And this does not include the cost and the greater trauma of her children who witnessed their mother's arrest. Experiences like Woodruff's are not only due to faulty technology, but inadequate procedures used by the people applying it, as well as possibly racially motivated policing. Although there's not much public information on the internal procedures that police officers use when they are deploying the technology, these 6 cases have some things in common. They did not require a supervisor sign-off on the match. They used non-eyewitnesses to identify the suspect from a lineup, and they proceeded with an arrest without any corroborating evidence. Police departments clearly need internal guidelines and requirements around the development, testing, and use of these systems to encourage responsible, equitable, civil rights preserving outcomes, which goes to my recommendations. First and foremost, we need to make sure that the government leads by example by being responsible and ethical in our use, not just in law enforcement, but among other government agencies that actually deploy it. We gave a lot of great recommendations that I will not repeat for the interest of time in the National Academy's report, and I urge the Commission to take a look. Further, we need increased appropriations to the National Academies and the National Science Foundation to do more research when we're trying to think about more inclusive data sets that allow these matches to be made, and to think about problems that may not necessarily be only couched about civil rights, but have sociological and technical implications. The federal government has to obviously come to agreement on what kind of congressional guidance we want. We've been sitting here on issues of data privacy and others, and without any type of congressional support, those guardrails will still be unaccountable. But most importantly, I think as we're having this conversation on federal mandates, we have to keep in mind that the federal government only has oversight in the area of policing over federal police. It is where states have more jurisdiction in the use of these technologies, and they often go under the radar with the same type of opacity when it comes to training, certification on use. With that being said, one recommendation is to come up with a federal fair and equitable use standard, one that could be co-developed between federal and state police, but it includes requirements for robust public disclosures and something I didn't get a chance to mention in my written statement, but I'll say it now, potentially citizen engagement. Being able to have that national fair and equitable use standard allows us to give some guidance as well as some enforcement to law enforcement in particular if they use it. And I would suggest that the same type of standards need to apply to federal agencies. In my written statement, I talk about other use cases like the IRS, what we're seeing potentially with students who have facial recognition embedded into the back ends of computers or school-issued laptops. We're seeing examples in healthcare. These future use cases are going to have implications for particularly people like Portia Woodruff, who had no agency or no awareness of how these technologies were going to be used. And my final recommendation is, what do you do with a Miss Woodruff, who now has to pay the legal expenses for her innocence and also deal with the trauma of her children? One of the considerations that we touched upon lightly in the National Academy's report, but I'll stress it here in my closing statement, is that the federal government should consider the possibility of retribution and compensation. Those individuals were already disadvantaged before the start, and now they have to find the legal fees to expunge their records because now they're actually in this system. What we do to actually remediate the harms for people like Ms. Woodruff from algorithmic discrimination is particularly important. And who pays the cost? Well, oftentimes it's the individual, when really, if the government makes a mistake, we need to figure out how to make it right. In sum, these recommendations before all of you, acting on the proposed recommendations of the National Academy's report, or at least considering them, developing a research agenda that allows us to look at the sociological and technical implications and maybe do something different by finding more inclusive data sets, developing that reasonable and equitable standard for FRT use among Congress or other federal agencies that are now going to be responsible for responsible and ethical use, and then finding ways to help people like Ms. Woodruff so that they don't walk away from these scenarios even worse scarred than how they started. Thank you very much, and I will look forward to your questions.
Thank you so much, Dr. Turner-Lee. We're going to now hear from Mr. Grother.
Thank you, Chairwoman Garza, members of the Commission. I am Patrick Grother, a scientist in the Information Technology Lab, part of the Department of Commerce, National Institute of Standards and Technology, NIST. Thank you for the opportunity to appear to discuss NIST's role in standards and testing for facial recognition technology. NIST's role in biometric and facial recognition technology is to respond to government and market requirements for biometric standards, including facial recognition technologies, by collaborating with other federal agencies, law enforcement, industry, academic partners to conduct research, measurement, evaluation, and interoperability, to develop metrics to support timely development of scientifically valid fit-for-purpose standards, and to develop the required conformance testing architectures and testing tools. NIST's work improves the accuracy, usability, and interoperability and consistency of identity management systems and ensures that the United States interests are represented in the international arena. NIST research has provided state-of-the-art technology benchmarks and guidance to industry and to US government agencies that depend upon biometric recognition technologies. Accuracy of face recognition today is assessed by measuring two types of error that the software can make: false positives and false negatives. A false positive means that the software wrongly considered photos of two different individuals to be the same person. A false negative means that the software failed to match two photos of the same person. This is important and has different consequences for different applications. A bit of background: for 2 decades, NIST biometric evaluations have measured the core algorithmic capability of recognition technologies and reported the accuracy, throughput, reliability, and sensitivity of algorithms to data characteristics. For example, noise or compression, and to subject characteristics, for example, age or gender. NIST biometric evaluations advance the technology by identifying and reporting gaps and limitations of current biometric recognition technologies. NIST evaluations advance measurement science by providing a scientific basis for what to measure and how to measure. NIST evaluations also facilitate development of consensus-based standards by providing quantitative data for development of scientifically sound standards. Since 2000, NIST's face recognition vendor test has assessed capabilities of FRT for one-to-many search applications and one-to-one verification. In 2023, the program was split into 2 parts: face recognition technology evaluation, dealing with who is in a photograph, and the face analysis technology evaluation, addressing things about the photograph, such as its quality. These parallel programs are today known as FRAIT and FATE. Participation is open to any organization worldwide. There is no charge for participation, and being an ongoing activity, participants may submit their algorithms on a continuous basis. The algorithms are submitted to NIST by corporate R&D labs and universities. They are prototypes and are not necessarily available as mature products. We post results on our website and identify the developer of the algorithm alongside. We do not do training of recognition algorithms. The evaluations provide the US government with information to assist in determining where and how facial recognition technology can be best deployed. Our results help identify future research directions for the FR community. NIST provides technical guidance and scientific support for analysis and recommendations for utilization of face recognition technologies to various US government and law enforcement agencies. While measurement of demographic effects, while face recognition accuracy has been supported by adoption of portrait photography standards first developed by NIST in the late 1990s, false negatives still occur with photos of significantly degraded image quality and with change of appearance, such as due to injury or natural aging. In December 2019, NIST released Interagency Report 8280, which quantified the effect of age, race, and sex on face recognition performance. The report analyzed one-to-one verification and one-to-many search algorithms separately and found that demographic differences in false positive rates are often much larger than for false negative rates. The report emphasized that the 2 types of error have different impacts and that these depend heavily on the application of the technology. The report recommended operational testing that end users should know your algorithm when fielded with their populations in their applications. The analyses in the 2019 report are now applied to all algorithms submitted to our benchmarks. False negative rates remain generally low, such that demographic variations are small. False positive rates remain variable and highly algorithm specific, with higher rates observed in women, in the elderly, and the young, compared to middle-aged adults. Regarding race, we see higher false positive rates in Asian and African faces relative to those of Caucasians. These effects apply to most algorithms, including those developed in Europe and the United States. However, a notable exception is that some algorithms developed in Asian countries give lower false positive rates with Asian faces than they do with Caucasian faces. While the NIST studies have not explored the relationship between cause and effect, the AI literature documents many instances where imbalanced training data causes underperformance with underrepresented groups. In 2022, we published NIST Interagency Report 8429, which was developed with Homeland Security, S&T, and with industry to establish summary measures for stating overall magnitude of demographic effects. This work was used to guide the development of an ISO standard, which puts requirements on tests. In 2024, we will publish a report which applies the standard's demographic summaries to recent one-to-many search algorithms. Additional recent work shows that measurement of performance across demographic groups is warranted in applications beyond just recognition. NIST Interagency Report 8491 looked at the performance of algorithms tasked with detecting whether a photograph is an attack photograph, meaning somebody wearing a face mask or presenting somebody else's photo. In addition, age estimation algorithms are also subject to demographic effects, nothing to do with recognition. In conclusion, NIST is proud of the positive impact we have had in the last 60 years on the evolution of biometric capabilities. With our extensive experience and broad expertise, both in its laboratories and in successful collaborations with the private sector and government agencies, NIST is actively pursuing the standards and measurement research necessary to deploy interoperable, secure, reliable, and usable identity management systems. Thank you for the opportunity to testify today.
Thank you, Mr. Crowther. We'll now hear from Ms. McCleary. Please proceed.
I am Laura McCleary, Senior Policy Director, and I'm so grateful to the Commission for the opportunity to testify today on behalf of Unidos US, a nonprofit, nonpartisan organization that is the largest Hispanic civil rights and advocacy organization. There is a clear and urgent need for updated laws and regulations to address ongoing infringements by uses of FRT and other technologies, and to apply constitutional principles like due process, equal protection, and privacy. How government sets standards for technology acquisition by the federal government, including by law enforcement and immigration agencies, could be a substantial lever to drive more responsible and democratic process and design. Because communities of color and immigrants are the first to be targeted and the last to benefit from technological change, this is one of the most important civil rights issues of our time. To date, we simply have failed to align constitutional rights with the cheap and routine surveillance of movement and biometrics aided by data collection on every aspect of our lives. And I want to depart from my remarks to reflect on some things that happened this morning. Although we heard from Clearview that they use public information, I want to flag that that sidesteps the question of consent and our expectations about the use of our personal data. Clearview acknowledged, for example, that there were expectations of privacy and the need for consent by its customers, but didn't say what it thought about consent for the rest of us who merely use the internet and didn't likely have an expectation that our information would be scraped, compiled, and used to train AI models and facial recognition technology. This is a conversation in some ways that circles around the issue of consent, and the same theme came up in the discussion around the airport. Why don't we opt out when we approach that checkpoint? Well, it's about the power dynamics of withholding our consent. We're approaching an official checkpoint that has the power to disrupt our plans on a ticket we've already bought. And most people would not be as well informed as you, Chairwoman Garza, that they can opt out without penalty or consequence. They would simply defer. So this question of power dynamics and how technology shows up in the real world, who knows how it works and who doesn't, that is the question that I think we have to grapple with when we're designing systems that can counterbalance our need to preserve civil liberties and protections for our constitutional safeguards against the exigencies that we have around the exercise of police power or immigration enforcement. I think we don't sidestep that by a mere technical discussion of standards. We have to think about the real-world testing and the power dynamics that are implicit in any of those situations in order to understand their civil rights implications. So relatedly, I want to make 3 points today. First, that the current uses of facial recognition technology undermines democratic norms and principles and threatens immigrant communities and communities of color. Second, that rather than providing exemptions or waivers for law and immigration enforcement uses, as was suggested by the Office of Management and Budget's draft AI memorandum, we need enforceable and binding standards for all surveillance technologies and AI models used to scale them. The question of how to balance state power with the preservation of appropriate zones for the privacy of individuals and groups within a democracy isn't new. It goes back to our founding and the creation of things like the First Amendment and the Fourth Amendment. Any healthy democracy has to have effective ways to address threats to law and order and the rule of law at the same time that it preserves a space for nonviolent protest, free speech, the ability to travel, and a zone of privacy around the individual that is both intellectual and physical. Third, our failure to align these systems with any appropriate governance framework perpetuates communities' exposure to unaccountable, opaque uses of technologies, including biometric surveillance. We have to formalize ways to elevate the voices of impacted communities in setting policy and set baselines for privacy with better laws that drive more constitutional systems and designs. So, many rightly raise the issue of inaccuracies, and we've heard a little bit about that today, that specifically impact communities of color. We share these concerns. We saw this problem in our work in Puerto Rico on the expanded child tax credit when the government's IRS ID systems routinely failed to recognize darker-skinned images of tax filers. Machine learning models generally are highly prone to biased inferences, and discriminatory outcomes are pervasive. But even if these profound issues of bias could be addressed, there are other fundamental problems to solve as well. So we mainly speak to those here. For the 62.1 million Latinos living in this country, the risks of overreach from intrusive surveillance are pervasive. Perceived efficiencies from current and planned uses in criminal justice, immigration enforcement, and related use cases will likely lead agencies to continue to gloss over deeply concerning data security, stewardship, privacy, and civil liberties concerns. And I think we heard about some of those gaps this morning in terms of the training, gaps that were flagged by GAO that still haven't really been acted on. There's some kind of module in progress, but we don't know what it is. An interim memo or interim policy that hasn't seen the light of day. There's lots more work to do around transparency and accountability at the basics. It is important for this administration to act decisively to address these risks. Immigrant and mixed status communities are canaries in the coal mines on civil liberties because they are positioned as test cases for policies that roll back all of our shared liberties. Rather than exemptions or waivers for law and immigration enforcement uses, we need enforceable and binding standards. And in my testimony, I explain how the NIST AI risk management framework provides these 7 factors that should be applied to any use of AI, including around FRT. We also face a rising risk of so-called automation bias, which is a propensity to place undue faith in outputs from automated tools. These concerns are heightened when power imbalances are pervasive, and there is every incentive, given a need for urgent situational judgments such as occur in policing or at our borders, to disregard the tool's limitations. Although the NIST framework calls for AI to be privacy enhancing, the memo's waivers could allow the most problematic and rights infringing use cases of AI to continue. We will not get to a consensus on how we can regulate privacy unless we grapple very specifically with the hard use cases. Otherwise, we're just circling around the drain. Our failure to align these systems with any appropriate governance framework also means that communities are subject to models that are unaccountable and opaque. We call in our testimony for a multifaceted governance model that includes inclusive red teaming, impact assessments, consumer complaint collection, a public leaderboard for metrics, and a requirement for consumer advisory committees for each agency, sub-agency, or department. They have to be able to tell technologists what they may not know, they do not know, about the way technologies show up in the world and with their lived experience. Setting a national floor on privacy also remains a high priority and is essential for establishing key safeguards for all of these technologies. We deeply appreciate your interest in this topic and stand ready to assist the Commission.
Thank you, Ms. McCleary. We're going to now hear from Professor Mulligan.
I believe it went on. Chairwoman Garza and distinguished members of the Commission, thank you so much for the opportunity to testify today about the U.S. government's use of facial recognition technology. I want to start by thanking you all for the attention you're paying to this issue and the work that goes into holding an event like this to hear from all stakeholders. I'm Deirdre Mulligan. I currently have the privilege of stepping away from my job as a professor at Berkeley to serve as the Principal Deputy U.S. Chief Technology Officer in the office of the White House Office of Science and Technology Policy. OSTP, as we are commonly known, is an interdisciplinary team working to maximize the benefits of science and technology to advance health, prosperity, security, environmental quality, and justice for all Americans. We carry out this mission by advising the President and senior advisors in the administration on key issues related to science and technology and by coordinating federal government technology policy and priorities. I want to start with one clear message. The Biden-Harris administration recognizes the risks of facial recognition technology, and we are taking bold action to address them. When this technology doesn't work, or when it's used irresponsibly, we've seen invasions of people's privacy, violations of fundamental First Amendment freedoms, and false matches and wrongful arrests, all of which disproportionately harm people of color. This is unacceptable and unjust. If we use this technology, we must use it responsibly. It needs to work. It needs to protect people's rights. It needs to protect their freedoms. It needs to advance equity. And most importantly, it has to adhere to our fundamental obligation to ensure fair and impartial justice for all. Advances in technology have challenged us before. Right? Each leap in capability brings new opportunities and with them new risks. I want to say to you today that deciding how and when to use and refuse technology, including facial recognition technology, is a key way our nation manifests our values. That is why, before AI chatbots and image generators were all the news, the White House released the blueprint for an AI Bill of Rights. It clearly states our values in a time of rapid technological change. It says we must protect the American public in the age of artificial intelligence. Steering by the light of those values, last year, President Biden signed an executive order on the safe, secure, and trustworthy development and use of artificial intelligence. And now the administration is finalizing guidance that will include requirements for the U.S. government's use of AI, including facial recognition technology. These actions are in a context. This administration's commitment to equity and using technology to support the public interest through ensuring protections for our safety, security, democratic values, and civil rights pervades everything the administration has done. Dr. Turner-Lee talked about the importance of data. On his first day in office, the president signed an executive order establishing a working group on equitable data, right? Focusing on making sure that the data we use to make decisions across all of government is representative and robust and meets the needs to advance equity. We've heard quite a bit about state, territorial, local, and tribal use of facial recognition technology. Part of the president's executive order to advance effective, accountable policing directed the Department of Justice, the Department of Homeland Security, and the Office of Science and Technology Policy, specifically my team, to identify privacy, civil rights, and civil liberties concerns and recommend best practices related to the use of technology, including FRT. Part of this effort, we will be issuing a report that includes recommended guidelines for federal as well as state, tribal, local, and territorial law enforcement agencies and technology vendors. You've already heard from Dr. Turner-Lee, about the National Academy of Sciences study that's supporting this work. I want to turn specifically to the Office of Management and Budget guidance for how federal agencies can use AI responsibly. This is an exceedingly important effort. The OMB draft guidance released for public comment last year would establish a rigorous set of risk management processes and requirements for government use of rights impacting AI, including FRT. This includes impact assessments to document the intended purposes, benefits, and risks, testing requirements, not just in the lab, but in the field, right? We need to actually view these things as socio-technical systems, and we need to understand their real-world effects. Ongoing monitoring and thresholds for periodic human reviews, requirements for agencies to identify, assess, and mitigate algorithmic discrimination, responsibility to notify individuals, particularly when AI negatively affects their rights, and to provide them with the opportunities and the material they need to challenge adverse decisions. And importantly, as we heard from Ms. McCleary and Dr. Turner-Lee, requirements to consult and incorporate feedback from affected communities. This guidance would be the most prominent national policy anywhere in the world to affirmatively center civil rights in the design and use of technology by government. Now, even with this guidance, we know there is still important work to be done. OMB has requested public input on how privacy impact assessments may be more effective at mitigating privacy risks, including those that may be exacerbated by AI and other advances in technology. We encourage all stakeholders to submit input to inform how privacy impact assessment can best ensure privacy protections for government use of FRT and other technologies. In addition, OMB is tasked with identifying and evaluating agency practices for procuring commercially available information and considering standards for its collection, processing, maintenance, and use. Such information is of critical importance because we know it is often the fodder that is used to develop FRT and other technologies. In closing, I want to emphasize that there's simply never been a more critical time to ensure technology works for every member of the public and protects our rights and our values, as well as our safety and security. I want to recognize the efforts of this commission and the important work you're doing to ensure the federal government is protecting our civil rights, and I look forward to working with you to make progress on these critical challenges and opportunities. Thank you so much.
Thank you so much, Professor Mulligan. At this point, I'm going to open it up to the commissioners to ask any questions of our panelists. Commissioner Jones?
Thank you, Madam Chair. I have a question for Mr. Grother. We heard earlier from someone at NYU's policing project, and I want to quote from Ms. Kinsey's written testimony, and I would like for you to respond to it because it directly talks about NIST. She writes, proponents of law enforcement's use of facial recognition often claim that algorithmic testing conducted by the National Institute of Standards and Technology provides sufficient independent validation of system performance. This is false. Although NIST testing provides an important benchmark of algorithms' technical capabilities, NIST doesn't test these algorithms on the actual low-quality images used by law enforcement. What are your thoughts on that statement?
Yeah, it's essentially true. We use data that we've got. I think the case in point there is that it's been a decade since we ran a test of surveillance data. So this is low quality data that you would collect maybe outdoors. We're about to remedy that situation in 2024 by rerunning that benchmark from a decade ago. That does include low quality data. It's right, so this is a photo taken, say, in a train station. The UK government provided us with that data a decade ago. So you've got cameras in a train station. Many people are walking, and if the application there would be to look for terrorists or other individuals, our benchmark is a first step at evaluating how well that would work.
I'm going to bring Dr. Turner-Lee into this just because something stuck out to me in your testimony about how original film was developed by Kodak, and I think it's something that not a lot of people know about, and I would love for you to delve into that and kind of how it interacts with what we just heard from Mr. Grother.
Thank you for that, Chairwoman. So in my testimony as a sociologist, and I was coming before this commission, I indulged myself in some storytelling and history telling about the history of photography. Like with other technologies, we see a base model or a base figure for the image, right? In this case, in photography, it was a white woman whose attributes were sort of seen as the standard for how we pixelate data. Now, this is back in, the early 30s when this was happening. Many of you, including myself, remember a Kodak camera and things like that had a certain type of pixelation with it. But the challenge is when we see these types of AI technologies sort of measured and trained on data that is reference data that includes a couple of things. Who is in the room in the design and development of these products, right? And in this case, it was Shirley, the Shirley card, as they called it. And from that reference, how do we then take that technology and build it out and then bring it for public consumption? What we've seen in AI, FRT, and many technologies is that reference gets embedded and baked in as an automatic bias in how we actually train these models. We're not talking about the research data that comes from people like myself who are subjected to the IRB and human subjects handling and think about the deviances that come with information. We're talking about market-based data. So just in the case as the invention of the photography, where that pixelation was very much placed on an image reference that doesn't look anything like me, what happens is as it becomes more embedded into AI technologies, it becomes the base reference. And so as Patrick has referenced in NIST, and we've been able to see a lot of that data, when it has some of these inaccuracies, much of it has to do with the representation of who's in the database. And the photo capture that was previously mentioned by the commissioner also has to do with who is overrepresented in certain databases. So who you find in that reference will automatically may not be trained on me, but you're going to find me because the people who are subjected to over arrest or deportation, et cetera, were in those databases. So if for those of you who want a history lesson, read my testimony because I actually really think that's an important part that we miss when we talk about photogenic quality and we talk about the history of photography. Thank you.
Commissioner Adams?
Thank you. Dr. Lee, it was interesting what you just said, and I haven't heard any witness today, and I don't think I've read it, I might have missed it, talk about the marketplace and solving this problem. Don't companies that do this have an incentive to sell good data and fix the problem you're talking about, or does that not exist in this space?
Well, you think they should, and thank you for that question, Commissioner. We hope that these technologies, and just for the sake of fairness, are optimized for people like me. We're in the same market. I'd like to be able to have my technology work and not have it misidentify me or like that young woman be falsely accused or have a false positive. With that being the case, this a paradigm of go fast, fix it fast, break it fast, and then go back and fix it later, has really driven the technology marketplace where, as it was mentioned by my fellow colleague here, tech companies can go to publicly available data to train these models. So it's not necessarily a standard as to what the input is. And as we've just heard from Patrick, it's not necessarily, a guarantee that that data that they're even certifying to our government agencies is going to be right. So to your point, we hope that companies understand the reputational risk and want to stay off the front page of the newspaper. And they also understand the fact that they're missing out on a whole population of people where the technology could be beneficial, not just for law enforcement, but in other use cases.
Yes, Ms. McCleary?
I just want to commend Unmasking AI by Dr. Joy Buolamwini to the Commission as a first-person narrative of and a political coming-of-age story that's quite moving and wonderful to read, but also one woman's struggle to be literally seen by the technology and all of the work that had to go into her work at MIT to document gradations in skin tone and create a validation system and then work to do advocacy with the companies to get them to accept. And they were all over the place in terms of the different companies being more or less receptive to this kind of input and feedback. Some partnered with her, others treated her as a critic. And I think this issue of representation in these tools is super important to understand. minorities will always be underrepresented compared to majorities, right? Because that is the nature of being a minority in terms of data points. And the systems don't think in terms of moral outcomes or about what should be. They think in terms of what is, and they derive stereotypes from that data set. And so there's always going to be a lot of need to correct for that problem that's intrinsic in some ways to the data, and you have to bring a lot of intention to that problem solving, which doesn't mean, around images that it couldn't be solved and facial recognition that it couldn't be solved, but the way that the data are treated around inferences that the large language models make in general is very difficult to solve for, because the more you chase the sort of most obvious ways the data classification is happening, the more the machine learning model can make inferences from things that aren't classified at all.
Thank you for that. We're going to go to Commissioner McIntyre and then Vice Chair Nurse on the phone. So we'll
I
start
have four
with.
questions, one for each of them. Sorry, this is good. Samantha Grosser at NIST. So obviously we've heard this cited often and often again. We see higher false positive rates in Asian and African faces relative to those Caucasians. I get it. So what do we do? How do we mitigate that? And I heard you say training. Is that algorithmic training? Is that user training? I don't know, and I'll look to you for that question, for that answer.
Yeah, thank you for the question, and it goes to Commissioner Jones's question as well. Low quality data is not necessary to observe these problems. Mm-hmm. These problems with different different regions of birth, say, exist even with high quality photos. So this is an algorithm responsibility. It's to fix it. And we've engaged the developers. We've given them a summary metric to optimize. This is Fitbit for face recognition. To give them a single number that they need to minimize. And it's essentially the disparity between error rates across demographic groups. Photography, as Nicole pointed out, is a separate problem that drives false negative rates. It's a smaller problem, but it can exist, and it's due diligence on the people who arrange for photographs to be taken. So the people who build cameras, people who install lights to fix that problem. I don't know if I answered the question.
No, that was excellent. I mean, especially making error rates equal across all demographic groups. Doesn't solve the problem, but at least it resolves the racial disparity, racial ethnic disparity. So I do understand that. Excellent. Thank you. Second question, if I may. Ms. Mulligan at the White House. I read your testimony carefully. The executive order issued on May 22nd, where the president directed DHS, DOJ to issue best practices and compliance. So I think I heard another testimony. I said other report that only 3 of the 7 agencies are actually doing it. So what's going on with implementation and compliance with the president's executive order?
So the work with DHS, DOJ, and OSTP that was specifically called for under the Accountable Policing EO is ongoing and underway. It is to produce a report that will provide guidance and best practices. I believe earlier today you heard from GAO, perhaps, the GAO report, which I read in full. And the questions about compliance with existing guidelines, for example, to conduct privacy impact assessments, is something that as I understand from GAO's report, both DHS and DOJ have committed to improve. I think that the OMB draft guidance that I have provided information about will apply across agencies, is rigorous, and goes well beyond the current requirements that are placed on any agency. And with those requirements in place, we will be looking not just to improve privacy practices, not just to improve the performance of algorithms in the lab, but to actually address the ways in which these systems affect people all across the country in practice, and to make sure that they do so in ways that respect people's privacy advance equity, protect their rights, and are aligned with our ideas about fair and impartial justice.
Okay, no, thank you. And maybe if we can just, for OCRE, if we can just get that OMB directive and also the presidential directives, because I saw a number of references to them, but I don't know what's in them.
Absolutely.
So that would be, or if you could provide it, that would be very helpful for our record.
I am happy to have my
Thank
staff
you.
will send them over.
Third question. We need us, Ms. McClary. Thank you for your service and your great work. All right. Were you here for DHS's testimony?
Yes.
All right. Reactions, thoughts? I'm giving you the floor. What did you, and I hear, but, you know, I really don't want to hear your thoughts about what you thought about what they said.
I think we have work to do, is what I heard, right? There are a lot of places where it seems as though the privacy protocols around the retention of data are a little bit surprising. 75 years seems like a very long time horizon to hold data on any population, for example. I don't understand the sort of fit to purpose of that length of time. I think immigration is in some ways the absolutely hardest case to think about these questions in, and so it's worth thinking about it at length, right? Because there you have to hold all sorts of values, and the population infected has diminished rights under our Constitution, and in some ways are the most vulnerable. So, go ahead, Commissioner.
And the national security interests are greater.
And the national security interests are greater, absolutely, right? And the sort of, and currently the environment that we have around these questions is very polarizing, right? And where we see these themes around immigration and immigrants being used politically. So I think there's, I think we have to be super intentional about this. It very much concerns me that given the GAO's, I think, D grade, I mean, how would you score that on a letter grade in terms of what the department needs to do, that there's been, I think, comparatively little response in a timely way to those recommendations. And I think in general, transparency is super important. Understanding the lack of power on the ground in a lot of the use cases is super important. What we know from some of the creation of surveillance towers and other kinds of deployment of data gathering tech along the border is that there are consequences to that. Migrants take more dangerous routes to avoid what they know about the surveillance towers, and face more dangerous conditions in terms of crossing the border. So we need to understand from a lived community perspective and an impact assessment perspective what the costs are specifically of use cases, and do a better job of making sure that those things are communicated with maximum transparency and with a concern for the rights of whole communities.
Sure. No, I heard that, and I think that's valid. Here's what I want to do. So it's a matter of public record. We will get you the DHS testimonies. If I could invite you, could I just give you some more work? I would love a written reaction to those, because I know they said a lot. Right, so if you can just give us to that, because I would like a balanced understanding, particularly because it's DHS and the work that is being done. Last question, Ms. Nicole Turner-Lee, thank you.
Only
No,
my
like
mom
this.
calls me that. Nicole Turner-Lee.
All
I'm
right.
in trouble.
No, it's good. So I heard what you said. If the government makes a mistake, the victim should be compensated. And again, and we actually have upcoming testimony from defense attorneys. I'm not sure if the witness is here, who'll be speaking to that. And you also said, make the data available to public defense. If law enforcement is going to do it, make that available for public defenders. So I'm not a criminal defense attorney or prosecutor, but they're under-resourced. Could you just say a little bit more about that happens? Why don't the traditional, like, torts of false imprisonment, you know, I think Congressman Ted Lieu said that in his written testimony that he submitted, he's not appearing here, said that there should be a private right of action. But you said that someone's already filing a lawsuit. So just walk me through, if mistakes will happen, even with the best system, how do we ensure compensation for the victim so that they can get the justice that after being wronged?
Well, I appreciate that question. I think if you don't mind, I'll just unpack it on two ways, right? So I think that there's still a lot of conversation that needs to happen in the use of facial recognition when it comes to investigation or use as a forensic tool, and the extent to which it's used for prosecution, right? And for many of us who've been following this, Representative Coons many years ago talked about facial warrants, and Ted Lieu the same. I mean, I have read his work, and I think he's pretty spot on, as well as with Congressman Clark, around what do we do to make sure people are protected. With that being the case, we have to come to some conclusion on the extent to which this is evidentiary, right? How do you bring this evidentiary information into a courtroom? And to my point, and if you're going to bring it on the part of people who are making the arrest, are you bringing it on the part of the people who are protecting those who may actually be innocent? Clearly, as my colleague has said here, Ms. McCleary, that there's this imbalance of power, and in law enforcement, it's even more so. So what does that mean? I mean, private right of action it's a pretty much a three-letter dirty word when we start to talk about that with regards to giving people agency over their data. In this particular case, there is no level of enforcement. Portia Woodruff, Robert Williams, and other folks, other people who are probably we don't even know about, can't sue an algorithm for any type of malfeasance. And so since you cannot sue the model, well, where do you go when you're actually in this space where companies have been indemnified from its use, or there's a mistake that cannot be retractable, and you now have other reputational damages and risk? All of the people that were arrested in some way or form spent a lot of time either incarcerated or with a legal defense attorney, had to come out and remortgage their home to be able to get that. That kind of goes, I think, not in tandem, but it's another element of this that we often do not disentangle. There's the technical side of this, and then there's the consequence. And on the consequence side, the other thing that we have to look at is to why I'm actually proposing this. Part of what we're seeing with facial recognition is its weaponization against communities that are pretty much overrepresented in any type of institutional database that's being accessed for criminal offenses. So we're not talking about, facial recognition in a healthcare scenario. When the IRS did it, we caught it in time, but it was for eligibility screening. In the case of law enforcement, it's a little different, right? We're talking about the fact that people of color are more likely to be arrested despite not doing the same amount of crime. We're already talking about a data set that is over-representative of people of color in it. We're talking about people of color in general who could be walking down the street and just be stopped just because they were walking on the wrong side of it. My point is they're going to be represented in some type of institutional database, and therefore will have some type of institutional reaction. If the government makes a mistake in some way or form, we should try to figure out ways to not indemnify ourselves from that mass surveillance, but to figure out how to fix it. The unfortunate thing, we as procurers of those technologies, last I'll say, we have no agency over the technologies we buy, we license, we purchase, and we distribute. We sort of assume that once it's in our purview that it's going to work correctly, and we indemnify the private companies if it doesn't. So my point is, at some point, whatever this mechanism is, if the government is going to be at the forefront of deploying these technologies, purchasing them, particularly the federal law enforcement side, we have to take some responsibility in their use. We're not going to train and certify people on our staff to use it. Then we need to figure out ways in which we protect local citizens from being the victim.
Thank you.
May I say one thing?
Okay.
I do want to note, because I skipped over it, I believe, in my spoken testimony, that the OMB draft guidance does have recommendations to manage the risks in federal procurement, because this is an incredibly important area, and we need to make sure that the technologies we're bringing into the government meet the standards required for government to use them.
That's why I want that in. I did not know that, actually, and especially as a matter of procurement, because we're dealing with vendors, makes a lot of sense. Let's.
Okay. Well, I appreciate that.
Thank you.
Wanted to make one note, but it's okay. One note, Ms. McCleary, that I'm really appreciative that you mentioned that book, Unwavering AI. I do want to note for the record that we did receive testimony from the author, Dr. Joy Buolawini. I'm so sorry, the founder of the Algorithmic Justice League. And before we go to you, Commissioner Jones, I do want to acknowledge that we have Vice Chair Nurse on the phone and give her the opportunity to ask a question.
Hello, can you hear me?
Yes.
All right, thank you. I just wanted to thank these panelists for your service. I am a professor. I'm sitting over here in Georgetown, and I apologize for not being there. But you really are doing amazing work, and you're doing amazing work by serving in the government as well. It's difficult, as you know. I know I've done it before. My office used to be across from OSTP. So I also just want to say, because I've been in and out because of technical difficulties, that I want to commend Commissioner Jones and his staff for putting this hearing together. It's really his work that has led us here. And I'm going to turn it back to them because they are the ones who have been leading this charge. Thank you very much.
Commissioner Jones?
Thank you, Vice Chair Nurse. Professor Mulligan, did you have an opportunity to observe the testimony, any of the exchanges during the first panel today?
I did not. I did read all of the testimony, but I did not have the time this morning to watch. I am sorry.
It is totally fine. You're very busy, and I don't expect you to have done that. You made a representation at the outset of your testimony that the Biden administration cares very much about many of the civil rights concerns, if not all of the civil rights concerns that have been expressed throughout the course of today's hearing, and is committed to fairness and equity in the use of FRT across the federal government. That representation stands in stark contrast to DOJ's refusal and HUD's refusal to not only send representatives to testify today, but to not so much as even submit written testimony, which is extraordinary to me. And so, two things. First, I hope that you will convey the disappointment of this commission to the White House when you return to the White House, and encourage them to at least produce written testimony, which we have not subpoenaed, though we could. And also, do you have any additional context that might help explain why HUD and DOJ refused to cooperate with our requests, which were timely made?
I do, like you, believe it is very important for the federal government, and as you know, a member of the Biden-Harris administration, feel it's very important for us to be here to talk to the commission about this important issue. I cannot offer any insight on my colleagues at DOJ and HUD. I will certainly make sure that I communicate your concerns back to both my boss, but also to my colleagues at DOJ and HUD. And I do want to say that the guidance that is in draft form, but that we are working very hard to finalize, is going to set a very high bar, and it is not something that can be ignored by any agency. And so I hope that by taking this sweeping action that addresses not just FRT, but other ways AI is used, we will be helping all agencies meet the expectations of the American public and meet the goals of this commission.
I appreciate that very much, and I imagine that guidance will be dynamic, and so when we release our report, hopefully our recommendations and our findings will be taken into consideration, maybe to the extent that you would update that guidance with some of those suggestions.
Okay. I see no more questions. I do have one question for Mr. Grother, and it's about the 2019 demographics report. You noted that system owners should test their systems on operational imagery to know how well or poorly they work, and under real-world conditions. How'd that go?
We made the recommendation now 4 years ago. We don't keep track of who does what afterwards. We would hope they would do it. Obviously, it's the acid test. Do it in your data, your population, your environment. That would give you data. I think operational testing, there are standards for operational testing, is not done enough.
And what's the value of operational testing?
insight into your real system on your real population. The reason you need to do that is because you can't just come up with a monolithic statement of how well face recognition works. It's all data dependent. Data dependent means photography dependent, environment dependent, population dependent. So you can't separate. You can do some good faith efforts to do testing in the lab, but the operation is where the rubber hits the road.
Yeah. And it's different in the real world versus in some of these controlled, more controlled environments.
Usually, if you take immaculate data from an operation and take it into a lab, maybe it's representative. But as soon as something changes, the lights go down, somebody changes a light bulb, things could change.
Yes, Ms. McCleary?
I would just add, I think there's also the human factors and training and education about the limitations of the data side that you also need to situate the technology in. And I was very interested in what DH said they were doing in terms of their Maryland Center around those kinds of advancements. That's a major area where we should have lots of expectations for all technology that's deployed of all kinds, especially when it's in use by officials with power making decision making, right? The staff interact with the technology. They need to understand how to use it well, to be trained on its implications, and to understand the legal and constitutional context in which it should be used or not used.
I appreciate that.
Yeah, if I could emphasize the importance of that real-world testing condition. And again, the OMB guidance, which is still in draft form, but when finalized, says lab testing is insufficient, right? And part of it is certainly about the images and how the algorithm performs with different kinds of probe data, different kinds of lighting. But it also is about addressing the socio-technical system, which is about automation bias. It's potentially about the people who are using the system and how tired they are. And so monitoring and oversight, so we actually understand its performance in the field, is critical if we really want to achieve our goal.
Dr. Turner-Lee?
Yeah, and if I may add, so as you all are doing some fact-finding, a couple things I want to put before you as well. The National AI Research Resource, I believe it is really charged with doing some of this responsible technology research where they're actually should be looking at inclusive data sets. So I would encourage the Commission to look at several entities, including the new AI Safety Institute, to put that on their radar for ways in which we make inclusive technologies and ways we would make, technical, we're testing for technical infallibilities. But the key thing is, we have some of those entities that are actually cross-functional that are bringing together researchers there. One other thing that I will also know, given the sensitivity of the Brookings Institution in this work as well, we've recently deployed an AI equity lab, which is actually intersecting many of the conversations that we're talking about now, but really bringing together the people who are technologists, sociologists, philosophers, ethicists, people from diverse backgrounds to really co-evolve what we think are some of the better practices when you are synergizing civil rights protection, technical cadence, and the ability of the technology to perform in high-risk scenarios. So things like AI in housing, education, criminal justice, you name it, financial services. We're going beyond the back of the napkin, but really trying to come back to you all with some really good data. So we're happy to also submit that for comment because we will be starting some of that work as well.
Well, thank you for that. I want to thank all of you again for coming here today and engaging in this really robust conversation about, not just this emerging technology, but what are the solutions? How do we create some safeguards and ensure justice is at the heart of this? So with that, we're going to go ahead and take a 10-minute break and reconvene at 3:15. If the panelists wouldn't mind indulging us in a photograph on the other side, we'll see you over there. Okay.